Thank you so much for the presentation, Marta. Thank you so much to the organizers of this prestigious conference for the invitation. When I received the invitation, I was thinking that it was a mistake and I would feel like an outsider here between this distinguished group of Central European professors. Instead, I have to say that I feel like at home with you, so thank you for the invitation. Today, I want to talk to you about how family laws. I should. Okay. This is my presentation title. Today I want to talk to you about how family laws are changing in many Western countries. But as a specialist in canon family law, I'm a professor, I don't look, because we have distinguished experts here. We heard yesterday 2 or 3 of them. And I don't look at the technical aspects, but I want to share with you the bigger picture. We know where family law comes from. It comes from Roman law and canon law. But where is it going is less clear. In the West, it seems like political agendas aren't seeing families as important for social progress. There is a gap growing between family law and its natural foundations, which are tied to biology and human nature. Family law used to have a clear reason and structure, but now it's a mix of different rules that don't always fit together. It's like a puzzle missing some pieces. In this brief presentation, my intention is to offer you a reflection, a humble reflection, I should say, on the main trends shaping the changes in family law in most Western countries, among which Spain, as many of you know, unfortunately, is a prominent example. Let's see something about the roots of family law. According to sociologist Pier Paolo Donati, the family is the specific place for humanization of the person through the full intersubjective reciprocity between the sexes and between generations, and it's not replaceable by other social forms. That is, family is an institution based on the natural difference between sexes and between generations. Traditionally, the family has been understood as the primary human community built on the stable commitment of a man and a woman oriented towards procreation and upbringing of new generations. Family law has historically aimed to protect this unit, ensuring its ability to fulfill its vital role in nurturing children and safeguarding vulnerable individuals. At the heart of family law are 2 core institutions, as you know, marriage and filiation, supported by more or less these 3 key principles. Marriage as a lasting commitment between a man and a woman, marriage as an institution linked and oriented towards procreation, and family ties rooted in natural and biological bonds, with adoption mirroring these connections to provide a loving family for a child who doesn't have one. Unfortunately, in recent decades, marriage and filiation have undergone a process of deconstruction. These are the words of Professor Carlos Martínez de Aguirre, who I like to repeat. So this deconstruction has 2 axes. If we see at the horizontal axis, marriage has long been the cornerstone of family stability, but it's been losing significance in family law for two main reasons. The first one, divorce has become easier. We have moved from fault-based divorce to allowing one partner at any time to end the marriage without the other consent. And the second, the equivalence of marriage to any form of cohabitation with or without commitment. The justification for these choices is mostly been the same: to ensure the satisfaction of spouses' desires for freedom. This is happening despite the evidence that marriage is a much more functional institution from a social standpoint than alternative models, and that its functionality increases with marital stability. Data also show that divorce has detrimental consequences for both children and the spouses themselves, both in personal and financial aspects. Let's see the vertical axis. Looking at the vertical axis, it is important to say that the lasting commitment between a man and a woman holds social importance only because it has the potential to bring new life into the world, ensuring the future of communities. Filiation law focuses on the natural bond between parents, father and mother, and their children, a connection inherent to all human beings and not created by culture, history, or laws. It is possible to assess several basic principles in this regard. The first, as a rule, biological parentage determines legal parentage, hence the possibility of paternity testing and the establishment of legal mechanisms to align legal and biological parentage. Second, the traditional cases where there was no alignment between biological and legal parentage were, to some extent, considered anomalous and tolerated by the law due to the lack of better solutions. Adoptive filiation is a creation of the law imitating nature as a way to provide a family for those who don't have it. And the best interest of the child is at the heart of filiation law. This is particularly evident in the case of adoptive filiation, where the law establishes the legal relationship as a form of child protection. These basic principles have been challenged in several ways, but perhaps the most significant disruption to the natural rules of parentage has come from assisted reproductive technologies. Originally developed to address infertility, these techniques have now expanded into a booming industry serving various types of couples, including same-sex couples. Initially, these methods have involved the genetic material of intended parents. However, over time, they have allowed for involvement of donors outside the couple, resulting in up to 5 different individuals contributing to the generation of a child. The implications of regulating these technologies in family law have been significant, and it seems that there hasn't been enough consideration of their long-term personal and social effects. Let's put a couple of examples. The first one was mentioned yesterday several times. It's the denial of the right to know one's biological origin, which indirectly has been endorsed by the European Court of Human Rights. While in adoption, the right to know one's biological parents is an achievement of human rights protection, it's concerning to see severe restriction on this right in assisted reproduction. The prioritization of donors and clinics' convenience over the child's rights is troubling. leading to significant limitation on access to information about one's biological origins, which denies individuals a crucial aspect of their identity and heritage. The second example is the lack of control of the suitability of those who will be recognized as legal parents. Of the two forms of filiation, determination by consent, assisted reproduction and adoption, only adoption undergoes administrative scrutiny to evaluate the suitability of prospective adoptive parents. The lack of control in assisted reproduction stems, in my opinion, from the acknowledgement of a right to a child without taking into consideration the child's own interests. We cannot see the following. No. Assisted reproductive technologies have expanded significantly, leading to the replacement of the gestational mother in surrogacy. This practice has turned into a lucrative industry governed by financial contracts. These contracts often grant commissioning parents extensive control over the gestational mother, encompassing her body, health, privacy, and decision-making, even extending it to end-of-life matters. It's important to recognize that this isn't just about renting a womb. Rather, it involves renting the entire person, both physically and emotionally. This practice can be seen as exploiting the gestational mother, especially if she's vulnerable, which goes against her dignity, but it's also, in my view, it's important to say this, it's also harmful to the child who misses out on maternal bonding and is treated as a commodity exchanged for money. This controversy has sparked movements. Some seek to legitimize these contracts through an international convention, mainly benefiting those involved in this business, while others advocate for the dignity of all parties involved and push for their complete international abolition, as did the Casablanca Declaration of March 2023. So, the main aspects in the deconstruction of family law can be depicted as follows. First, we can talk about the biologization of family law, biological connection. Let me put the glasses because biological connections are replaced by purely psychological bonds based on will or desire. It's not about whether you are or not a parent, but rather if you want to be one parent. Second, oversized role of freedom and desires. If parentage is solely based on will and desire, it's hard to justify its unbreakable nature. Third, we can talk about the submission of law to technologies, which can be named as technocracy. The law is being dictated by what science can achieve and by the biotechnology industry. Legislation in many countries has been accommodating to biological advancements, simply following and formalizing the demands of reproductive medicine. Fourth, never before has there been such emphasis on the best interest of the child, yet legislation is increasingly focused on the desires of adults. This phenomenon, which yesterday I was happy to hear the same word, adult-centerism, is a prominent feature of modern family law. And lastly, we can observe that the underlying purpose of family law, particularly in matters of parentage, has been obscured. As noted by Professor Mary-Ann Glendon, many recent challenges in family law don't seem to arise from a clear set of objectives. These legal developments appear to be random and almost arbitrary in nature. Let me just think on some of the consequences of these changes for demographics. These trends also have effects on demography. Statistical data suggest a link between changes in family law and a decline in fertility rates. However, other factors also play a role, such as delaying starting a family and economic insecurity. Family stability makes the decision to have children more difficult. This is especially evident in unmarried couples, but any form of uncertainty can make the commitment to parenthood more challenging. Several studies indicate that many people opt out of parenthood due to fears to repeating their parents' mistakes. Some individuals feel that bringing children into an uncertain world is illogical. And the glass generation, I don't know if it's just, this name is only in Spain, we call it glass generation, you don't, glass generation should be like the last generation who is very fragile. So this is because the glass generation acknowledges that they are not ready to take on the responsibilities of parenthood, with some preferring to spend their resources on travel rather than raising children. This should be from a qualitative study in Spain. So I don't want to, to be pessimistic, and this is because my last slide is on realigning family law. So to reconstruct, we have talked about deconstruction. To reconstruct family law and restore consensus on this complex issue, we should abandon rigid ideologies and instead listen to the voice of nature. Only by listening to nature's voice, we can break free from the technocratic trap, which sees technology as a means of possession, control, and manipulation, as noted by Roszak and Pope Francis in Laudato Si. We must also avoid falling into the trap of equating scientific and technological progress with human progress. And there is a quotation of Pope Francis in Laudato Si, which I want to read because I think it's very enlightening. Ecological culture cannot simply be a set of reactions to immediate environmental issues. We require a distinct perspective encompassing ways of thinking, policies, educational initiatives, lifestyles, and spirituality, all of which collectively resist the prevailing technocratic paradigm. This endeavor will pose challenges, yet is it not impossible? Just as effective public health policies have successfully reduced tobacco consumption despite opposition from manufacturers, or ecological awareness is prompting us to rethink issues such as responsible consumption and healthy eating, the reconstruction of family law must include a return to its fundamental purpose, placing the best interests of the child above the desires of adults and regaining the importance of biological bonds within the family. The emerging ecological sensitivity should be taken to its logical conclusion, as proposed by Pope Francis in Laudato Si, because everything is connected. once the human, as this is also a quotation of Pope Francis, once the human being declares independence from reality and behaves with absolute dominion, the very foundations of our life begin to crumble. So, and this is my last word. So our challenge, it's of course, it's not only a challenge in the field of law, but it's mostly a cultural challenge, which includes education, spirituality, styles of life, to regain trust in the family as a natural institution, which is, as we know very well, the key to the survival of humanity. Thank you very much.